Hey guys, this is Vicki and welcome back to Courtroom Clapback. Today we're headed to Michigan, into the courtroom of Judge Oakley, where he's hearing a case of a 20-year-old, Mr. Wallace, who has been charged with operating a vehicle while physically impaired, along with failing to report an accident. And Mr. Wallace has a pit bull of a defense attorney. And is it just me, or are we hearing more and more defense attorneys talking to judges about the fact that a guy's brain is not fully developed until they're 25, as if that is a mitigating factor? And also the defense attorney is saying the prosecutor has no other proof other than his client's own words that they're using against him. And his client was 3 times over the limit for alcohol, and he never should have been questioned. He has a lot more excuses than that. But let's head into the courtroom and find out if Judge Oakley falls for it or if the prosecution is able to blow the defense attorney out of the water. And you guys, drop your comments below, because after this, I want to talk about it. Okay, have fun. Enjoy the case.
All right, ready for argument. And you guys don't have to jump up.
Your Honor, in this case, just briefly, my client was stopped, walking down Will Carl. The police came upon him because of 2 911 calls. One is suspicious because it came from my client's own phone. From a distance away from someone else's house. The second one is a valid 911 call. Valid. It's credible because the caller gave his first and last name. Said saw someone walk down the road, looked intoxicated and stuff. Where they used to call. Neither of these calls put my client behind the wheel of the car. The first one says there's a car in a ditch and there's someone on one road and there's someone walked down another. The police come, they talk to Mr. Wallace, and he makes some statements that that's what ends up getting charged with operating while intoxicated. He was never Mirandized, but even if he was, it doesn't really matter. The statement that Mr. Wallace made during his interrogation are in this law lesson voluntarily, knowingly, and intelligently he waived his right to self-incrimination. They must have been made with full awareness of both the nature and the right being abandoned and the consequences of the decision to abandon. The people quote Bergman and Oregon as stating that the police don't have to Mirandize people on traffic stops. I understand that argument. I've made it myself before. The difference here is that the people can completely ignore Cipriano and Stewart. In Cipriano, there's 11 factors looking at whether or not the statement was knowingly made. The age of the
Oh, that's 2 different issues, though. First is, should they have Mirandized him? And your argument is, Miranda or not,
Miranda
statements aren't usable. Yeah, so let's not mix those 2 arguments. Right. Let's talk about first one first. Let's talk about whether or not they should Mirandize him. Unless you want to just skip that one.
I'll skip that one because I think Bergman and Oregon control on traffic. So
Okay.
say this is a traffic stop. They were walking down the street. It's more akin to a Terry stop than a traffic stop. But even if he wasn't Mirandized, I think Cipriano and Stewart control that, because Cipriano looks at whether or not constitutional advice would render whether the person was Mirandized. It's one of the factors, and none of the 11 factors control in and of themselves. Cipriano looks at the totality of the circumstances, so they look at all of the factors together, along with everything else. So whether or not he was Mirandized, I don't think is the issue here. It's to allow you to suppress the statements.
All right, then let's talk about the other factors.
In Cipriano, the control are the age of the defendant, the extent of the prior police contact, defendant has had, lack of constitutional advice, injury, intoxication, or ill health of the defendant, and if you deprive private food, sleep, or medical assistance. My client Mr. Walsh was 22 days away from his 21st birthday on the date of the stop. Stewart was an 18-year-old. There's not a lot of difference between a 20-year-old and an 18-year-old, I believe. He was young. He didn't know, because he's not, development's in frame, not complete yet. He's not a juvenile, but he's not an adult, fully formed. He hasn't had any prior police contact. He's not aware of his rights completely. He wasn't Mirandized. He was highly intoxicated, and he was potentially in an accident. He did ask for medical care. He was taken to the hospital. The blood draw that came back was 0.25. It's exceedingly high. It's 3 times the legal limit to draw. I find it difficult to believe that you can say you're too intoxicated, but yet we're going to take every statement you say against your own self-interest as the main. When you add in, you take all of that and you add in the facts of the first 911 call. I included an affidavit in compliance and other. The people say they don't understand the reasoning for that. The reasoning for that is Ms. Wallace, when retrieved Mr. Wallace's phone that day from this other individual, Mr. Speed, who I believe made the phone call. I believe the phone call was made from that phone for 2 reasons. One, there's a screenshot of my client's phone saying it was used to call 911 at 11:40 on August 2nd. And 2, when you listen to the 911 call, the individual who says his name is Brandon is talking to the 911 saying that there's a car in a ditch. It's a 300 Chrysler, it's black, and there's someone walking down Will Carlton Road. While he's making that phone call, while he's making that 911 call, an automated message from Mr. Wallace's iPhone breaks in and says, the owner of this iPhone has been involved in a serious car accident. They're not responding, and they give GPS coordinates. And those GPS coordinates just happen to be Mr. Speed's house. So there was another person in the car. It's entirely possible that Mr. Spino was the driver, put the car in the ditch, and took off with my client's phone, and he made this phone call at a later time. That's reasonable doubt for a trial. I understand that. But when you look at that and you put it all together, there is reason to doubt my client's statement because of his level of intoxication, because someone else was there and was potentially driving, because no one saw my client driving. I believe these statements should be suppressed. I believe that they're not credible based. And without these statements, there's no one to put it. Mr. Wallace operating the vehicle.
Anything else at this time?
No, Your Honor.
Madam Prosecutor.
Statements such as I parked it there, I just stopped there, and I figured I would just walk the rest of the way and get it towed. I ain't going to bullshit you. I am obviously way too intoxicated to drive, and that's why I stopped. Defense wants us to believe the defendant was still undergoing physiological and neurological maturation, was unable to fully understand or appreciate the situation and the statements that he had made. If we were to apply this standard, then all men in their late teens and early 20s would be given a pass to commit crime up until their prefrontal cortex had fully developed. Defendants made multiple decisions that day. He made a decision to drive drunk. He made a decision to make these statements. He made decisions such as electing not to complete field sobriety tests. He made decisions not to, when asked where he got the alcohol, he told police that he didn't want to tell them. He made decisions such as when they asked what friend's house he was heading to, he did not tell them. He made all of these decisions that day. I find it hard to believe that he can make all of these well-informed decisions, if he wasn't able to fully understand those statements, such as I parked it there, I drove, all this other statements that he made as it relates to driving his vehicle, but can't appreciate the statements such as not giving consent to do field sobrieties and stuff, and or a PT or anything of that nature. He also told police that he knew his laws. He told police that he came from a background of law enforcement officers. He was making very clearly informed decisions based upon the situation.
Respond.
Yes, Your Honor. One, I don't believe that you can take one instance, this case in particular, and paint everyone's getting a free pass for committing crimes because they're not over 25. That's not the point. My point is fully looking at his age. It's one instance. It's of the Cipriano factors that goes towards the entirety. So we're not saying that everyone gets a free pass because they're not fully formed yet. That's a broad generalization of people, not our point. Again, age being one factor, the level of intoxication being one factor. You could have said killed Kennedy, doesn't mean it's killed. So I think that everything needs to be looked at much more closely and not just cherry picked. Well, he said he was drinking driving, so obviously he wasn't. When there's no other corroborating surface, no other corroborating evidence whatsoever, not even the 2 911 calls put him in the vehicle. I saw a guy put his car in a ditch and now walking down the little car. That would at least be some circumstantial evidence that he was operating the vehicle. People also raised the fact that the car was tied to his mother, that one of his credit cards was in the car, and that he had a key fob in his pocket. So, obviously he was driving. Having a key fob for a new model car doesn't mean that you're operating. It means you could be sitting in the passenger side seat and someone could push the start button, the car starts. You could be next to the car and someone pushes the start button and it starts flipping, you're operating. Looking at everything, again, looking at the totality of the circumstances, including the suspicious 911 call. I believe causes a credibility issue with the statement of a 20-year-old who had a .25 BAC.
Anything else? Let's talk specifically about Cipriano and how it applies to these facts.
So let's see. So the age of the accused, the defendant was a couple of age shy of 20 years old. In my investigation, at the intelligence level, I understand that when he told police, he explained that he had a lucrative career as some sort of stunt murderer, content worker, what have you. He obviously knew, he told police that he understood that he could not drink. He understood that he should not drive when he was intoxicated. He had knowledge and wherewithal to know that these things were wrong. The extent of his previous experience with the police, I know that he had no priors, so I have no reason to believe that he knew, but he didn't know they were police, they were fully uniformed and what helmeted at themselves as police officers. Going to the detention of the accused before he gave the statements in question, he almost immediately stated that the car was illegal. He went on to say all these other statements just within the first couple of minutes of interaction with the police. The lack of any advice to the accused of his constitutional rights. Again, he knew that he told the officer that he knew his laws, that he had police background or through his family. He made decisions such as not doing the PBT, not doing field sobriety.
How's all that fit Cipriano though? The fact that he made decisions, how's that fit Cipriano? I understand his statements that he knows law enforcement, he knows cops, whatever, I know my rights, whatever that is. I understand how that would fit to his educational level, but how does all this other stuff you're giving me fit Cipriano? Having made other decisions?
I mean, well, there was, I'm sorry, the lack of any advice to the accused of his constitutional rights, because he knew that, he stated that he knew the laws.
Right.
Knowing the laws, knows that he can say no to certain things, such as the PBT and field sobriety.
Okay, anything else you want to say about Cipriano?
I think those would remain factors if you wish.
If you think they help you.
I guess we can start where, whether the accused was injured, intoxicated, or drugged and in ill health when he gave the statement. He did have a very, very, very high case. Was intoxicated, but frequently in the other case, people are intoxicated. That is probably 15% of traffic stops are drunk drivings. In order to investigate drunk driving, you have to ask questions of the individual. He did tell the officer that he needed some sort of medical intervention about half an hour into the investigation. Officer Nally immediately called for assistance. Officer Vito Secchi was on scene. He is a trained and certified EMT. The defendant could not articulate what was wrong with him other than not feeling well. I think that would be the last one.
Okay. All right, anything else?
Yes, you are. I understand that, the voluntary injection of food altering substances, alcohol and drugs isn't, a defense between on. So we're not talking about whether the crime was committed here. We're talking about the statements that were made that would link my client to these charges. And again, I think it bears repeating, a 20-year-old with 0.25 alcohol beyond and underage drinking, everything else goes along with it. I think looking at taking that into consideration with his statements, who knows what he's saying is true, and there's no other corroborating evidence to put him behind the vehicle operating. All you have is these drunken statements with no other proof. With that, I believe statements can't be looked at as credible.
Anything else? Anything else?
No.
All right, it's a close call, counsel, but I'm going to deny your motion. I encourage you to appeal it. Anything else? Good luck.
Okay, guys, what do we think? How do you think the defense attorney did? Actually, I think he had a point. If it is true that they did not read him his Miranda rights, that would be a problem. If that was my 20-year-old son who got pulled over, I would have a problem if they didn't read him his rights and let him talk without, having counsel there. Of course, if it was my 20-year-old granddaughter that was driving down the road and this drunk driver was on the road, that would be even worse. So, he said my client's phone, the call came from, the 911 call came from my client's phone, but who's to say that he was the one calling? So, I don't know. I think the prosecution pretty much blew him away. What do you guys think? He was, he had the presence of mind to refuse to do the test for drunk driver test, the sobriety test. And he made some, the prosecutor was saying that he made some really well-founded decisions in his own favor to protect himself. He had the presence of mind to do that. He wouldn't tell them where he was going or came from. He admitted, though, that he should not have drank and drive. So I think this is going to trial unless there's a plea deal to be made, which usually happens. They don't want to tie up the courts with this. I don't believe anybody was hurt. What do you guys think? On that note, until our next case, I will just say court's adjourned, and I will see you soon.